Our next speaker is Osagie Imasogie. He is the co-founder and senior managing partner of Phoenix IP Ventures, as well as the chairman of the board of directors of Iroko Pharmaceuticals. He serves on the board of Stonebridge Investment Partners, a money management firm with $861 million assets under management, and is the chairman of the advisory board of Cohen Capital, a Philadelphia-based investment bank. He is also a member of the New York State Bar and has been the I. Grant Erie adjunct professor at the University of Pennsylvania Law School, where he teaches a very interesting seminar on intellectual property and national economic value creation. He holds postgraduate degrees from the London School of Economics and the University of Pennsylvania Law School. His talk today is titled Value Creation in Intellectual Property, the Foundation for Venture Capital and PE Investing. Would you please help me in welcoming Mr. Osagie Imasogie?
All right, you are obviously the most stalwarty individuals who stayed to the end, to the bitter end. I think there's one more speaker after me, so I'm going to make my talk relatively quick. I'm going to talk about something that I have a tremendous amount of passion about, and something that I think is become very, very important, and most of us are not conscious of it, which essentially is the interface of intellectual property and the value creation in various economies throughout the world. And since I'm in the private equity business, this is a crucial part of what we do. Oops, I went in the wrong direction, I seems. All right, so first things first, what is intellectual property? Does anyone here know? Give me an idea. Pardon? Yes, sir.
Intellectual property?
Yes. What is it?
Patents, trademarks, copyrighted material, and
Good. Give him a gold star. Okay. You're absolutely right. Right. Intellectual property essentially is a legal construct. And why is that important? It's not real. We made it up. We made it up. We decided that a bunch of things are going to be protected by the law. It's one of those unique forms of property that cannot exist without legal activity. Simply cannot. If you own a pencil, there are those who would say, hey, that's Nico's pencil. And if someone wants to take it away from you, they have to fight you to get it. So you don't need the law to protect your pencil. This is your pencil and you hang on to it. You might need some muscle to protect it, but you don't need the law to do that. How do you protect the Nike swoosh mark? How do you prevent 1 million people from copying it? There's no way you can do it without the law. So this is a legal construct. We just made it up. And you're going to see how important that made-up property is. So you've got patents, and patents, copyright, trademarks, trade secrets, unfair competition. These are different types of intellectual property. Each one is valuable in its own right. Collectively, they represent a tremendous amount of value. It's all around us. Okay? I'm just showing you here a slide that captures some marks, most of which you know very well, but behind each one of those marks, each one of those trademarks, you actually have all forms of intellectual property. So behind a Google trademark, you've got the trademark, you've got the patents around it, you've got copyright around it, you've got trade secrets, you've got unfair competition. So each one of these marks has at least 4 levels, if not 5 levels, of intellectual property behind it. And each level of intellectual property is of tremendous value, okay? And it's all around you. You live it, you breathe it, you wear it, you eat it. I'm going to talk about that later on. So here's where we are with intellectual property. I love cartoons, nice little cartoons. Now we now own all rights to your image. You have to pony up $100 to the company every time you look in the mirror. Sounds funny, right? Guess what? The silhouette of Elvis Presley, the silhouette of Michael Jackson, is copyrighted. Not too far from the truth. You can't use the silhouette of these individuals because they are so famous that without paying for it. So this is the extent, this starts to give you a sense of what is happening in the world of intellectual property. So I tend to refer to it as the new global currency. And that, of course, is somewhat a brash statement, right? Because what do you mean it's a new currency? Well, let's talk a little bit about that. It's a new currency with a very, very long history. I tend to point to, within the American legal system, I like to point back to the English legal system, which is where the American legal system was derived. And as early as 1623, 1624, Parliament in England passed what is known as the Statutes of Monopolies, or the Statutes of Anne, depending on who you are speaking to. And what they pretty much did was that they took away from the sovereign the right to grant patents generally. So before then, the King and Queen of England, when they were broke, guess what they did? They would give one of their friends the unilateral right to be the only one to produce salt in Manchester. Well, if you are the only one to produce salt in Manchester, you become very, very wealthy in a very short period of time. So Parliament took this right away, claiming that the sovereign was abusing it. But what did Parliament do with the right? They kept it for themselves so that their friends could get these rights. Okay? And that was the beginning of the British patent system. One peculiar aspect of that patent system is that it protected the first person to bring new technology into the realm, into England. So what do you think that meant? Can anyone understand what that fancy phrase meant? Who was being protected? The first one to bring new technology into the realm. Who was being protected? No? Another brilliant suggestion? The guy who smuggles technology into England, the thief. The whole aim of the Statutes of Monopoly was, at that time, England was a backwater technologically. It was the Netherlands, it was Italy, it was France that had very crude technology. So to encourage someone to bring it into England, they give protection to the thief, the guy who smuggled it in. And that person now will have an exclusive right to practice that art within England. Why is this important? It's because the basis of almost all intellectual property laws is we made it up and we supported people who stole things. And that's the way we industrialized. That's reality. What did we do stateside? Well, our own was even more unique. We have, as part of our Constitution, a provision about intellectual property. It's absolutely phenomenal. It's like opening up King Tut's tomb and seeing a cell phone in his hands. Okay, that's how radical this is, right? So in 1776, you have a new nation, and shortly afterwards, in the first section of the Constitution, the first article in the Constitution, you have the provision protecting intellectual property. Can anyone guess why that is the case? Why in the world would we have Article 1, Section 8 of the Constitution of the United States, a section about intellectual property? We're building a whole new country. Why would you do that? Any suggestions? Yes, sir.
To protect, or to like foster creativity. If I'm gonna like invent something new and put it into the flow of commerce or whatever, there's no incentive for me as an entrepreneur, for me as an inventor to do that if there's not gonna be any protection behind it.
I hear you loud and clear, and I totally agree with you on that. We can have another debate later on. I totally agree with you. My question, however, was, why is it in the Constitution? Why will it be in the Constitution? Why will it be in Article 1 of the Constitution? Yes, ma'am. Absolutely. And who are the they here? Benjamin Franklin is at the table. Jefferson is at the table. These guys are themselves inventors. Didn't you watch the movie with Nicolas Cage? Come on, okay? These guys were inventors. They immediately understood the value proposition involved. There were actually 2 drafts of this section. Unbelievable, right? So this is in the 1700s we put it into the Constitution. Right? So this has now become the base of our economy. And the quotes I gave at the end here are quotes from the United States Supreme Court about the value of intellectual property. A patent for an invention is as much property as a patent for land. In fact, there are Supreme Court cases that say intellectual property is of a higher value. They use the word divine, that is divine, for something that we made up. Okay? But this is the view. Intellectual property for us has become so crucial. So why do I call it a currency? Take a close look at this slide. This is just the value of the brand. Not the value of the products, just the trademark, right? IBM, I mean, you've got Apple at 182 billion. Yeah, that's billion as in butter, B as in butter, right? For the trademark of Apple. If you write Coca-Cola, that's $74 billion of value. I mean, think about this is just, and this is in the easiest to create form of intellectual property, which is a trademark. You come up with a design that is unique, you put it on a piece of paper, you file it with the USPTO, voila, you got your trademark. Right? You could do this sitting in the loo. Come up with the mark. And in time, hey, it could be worth a couple of $1 billion. So when I say intellectual property is the new global currency, you are just getting a peek at it, of what the value proposition is. All right. Let's talk a little bit about copyrights. Michael Jackson passes away. 48 days later, he's made $100 million. Does anybody know the length of copyright in the US? Who?
17 or 28? 17 years?
Nope, that used to be patents. But it's not 20. Yes, sir. You're absolutely right. It's the life of the author plus 70 years. It is the life of the author plus 70 years. So if the author lives to be a ripe old age of 90, it's 90 plus 70. Okay? That's why Michael Jackson made $100 million 48 days after he died. You get it? For the next 70 years, the Michael Jackson estate will be making money. As long as people like his music. Or a variant of his music. Or his silhouette. Or his gloves. Or his hat. You can keep on making money from this. Presley has made more money since he died than when he was alive. Go figure. The guy made $55 million in 2011, 34 years after his death. I mean, think about it. I may be dating myself. Casey and the Sunshine Band. That's the way I like it. That makes money. That's what they say throughout the song. But they make money. Okay? This is the power of copyrights. Okay? Patents. There's a case going on in the US Supreme Court right now. There's a fascinating case that involves something known as BRCA 1 and 2. There's a company, a publicly listed company called Myriad Genetics. And what they did is that they figured out that if you, unfortunately, if someone is faced, if a lady is faced with breast cancer or ovarian cancer, particularly with breast cancer, the disease can take 2 routes. One, a relatively moderate progression, and another, a very, very aggressive progression of the cancer. What Myriad Genetics figured out, actually it was the University of Utah that figured it out, and the Myriad Genetics then acquired the license. But what they figured out was that there was a particular mutation, which they call BRCA1 and BRCA2. And if a lady has this mutation, it's more likely that the progression of the disease will be aggressive. So what they figured out is that knowledge, is that correlation, that this mutation is more predictive of an aggressive course of the disease. If you know that, then your doctors can treat you more aggressively and stand a better chance of saving your life. Okay? Now, this is important. This knowledge doesn't help you treat the disease. It's just a signpost to say this one is going to be aggressive. Well, guess what they did? They filed a patent on that. So here's the problem. The minute you draw the correlation between the mutation and the path of the disease, then any kid in a high school lab can take your DNA, look for the mutation, and predict. But if you dare to do that, you are breaching their patent. They charge around $3,000 per test. Per test, $3,000. And there are some people who thought that this was absolutely ridiculous. So the ACLU brings a lawsuit against Myriad and against the US Patent Office and sues everyone and their mother and says, you can't do this. This is ridiculous. So far, the US Supreme Court has said, what's wrong with that? Makes perfect sense. Here's the thing you should think about. Approximately 25% of your genes, including mine, because I think I'm part of the human race, has been patented. Yeah, seems cool, huh? Seems scary, huh? There are some analysts who claim that it's up to 41%, but no one is disputing the 20-25% number. So everyone in this room, 25% of your genes are owned by companies. Well, let's keep on chuckling because I'm going to tell you about another lovely case. Moore versus Regents of UCLA. This case is particularly interesting. There was a chap called Mr. Moore who was a construction worker, lived in Seattle. He was diagnosed with something really horrible called hairy cell leukemia. Even the name is scary, right? So this poor chap is told he has hairy cell leukemia, and one of the world's leading experts in this area was a professor at UCLA who has a wonderful name, Dr. Gold. And Mr. Moore leaves Seattle to go and see Dr. Gold at UCLA. Dr. Gold sees him, and in examining him and taking some samples from him to test, Dr. Gold discovers something really cool, that Mr. Moore has a mutation in his gene that could allow Dr. Gold convert his gene to what is known as an immortal cell line. In other words, he could take a piece of Mr. Moore and make it live forever so that he can use it as a template to test drugs against. This is extraordinarily valuable. Well, for 6 years, the good Dr. Gold does not tell Mr. Moore that he's figured this out. Instead, he mines Mr. Moore. Cool stuff, right? For 6 years. This poor guy, he's been treated, he's coming down from Seattle to UCLA, and Dr. Gold is taking more and more body parts from him. He takes his spleen, he takes his blood, he takes this. And what does the good, enterprising Dr. Gold do? He files a patent on it. Mr. Moore doesn't know. UCLA gets the patent, it's the name of the university. The good Dr. Gold goes and licenses the patent from UCLA, sets up a nice little company. The company owns the patent now, and he licenses it to a big pharma company. And Dr. Gold is making good money. 6 years later, somehow, the good Mr. Moore discovers that he's been mined. And he has a slight objection to that. And he brings a suit against Dr. Gold at UCLA and all these lovely people that he sold sandals. He sues everybody. Here's the interesting part of it. Supreme Court of California says, what's the problem? That Mr. Moore has no rights to his body parts. That when you go to see your doctor and he takes a sample from you, that is medical waste. And we have policies against letting people keep medical waste. So the minute the sample was taken out of him, including his spleen, by the way, he didn't want it anymore. And the Supreme Court of California said the only thing that the good Dr. Gold did was he didn't really inform Mr. Moore. So the issue here was the lack of informed consent. Now, that case has been cited and upheld repeatedly through our country. Let's make sure we understand what it means. Remember what I said about the good Mr. Moore? What did I say he was? He was a what? Construction worker. So what educational level do you think a construction worker has in Seattle? PhD? A Northeastern University graduate? Huh? So most likely the good Mr. Moore was a high school graduate. He's been diagnosed with a horrible cancer. He goes to meet the world's leading expert. And according to the Supreme Court of California, if Dr. Gold had said to him, look, Mr. Moore, I do research and I do business. So anything I take from you as I treat you is mine. Here's a piece of paper where I've now informed you. If you sign that, I will treat you. If you don't sign it, go and get another doctor. It's not complicated. And according to the Supreme Court of California, if the good Mr. Moore had signed it, Dr. Gold did nothing wrong. Sounds reasonable, right? Do we realistically expect Mr. Moore to say, no, I'm not going to sign it? But this case is just another example of the value that intellectual property has. In fact, this case is so cool that Michael Crichton used it as the basis of a nice novel called Next. So if you have fun, if you have some time, go and read the novel. It's really, really cool. But he uses it as an example, and in his novel, in the extreme case, someone goes and the equivalent of Dr. Gold makes a lot of money, someone who's competing with Dr. Gold goes and corrupts his immortal cell line. And the good Dr. Gold, now this is a novel now, it's not the case, but the good Dr. Gold character in Michael Crichton's book then goes to court and gets a court order to go and mine Mr. Moore, some more. He wants to get more out of more, you know. Anyway, so interesting story, but the point in issue is that this has become the reality. This is the new global currency. This is when I say currency, this is what I mean. Look at what is happening on the public markets. If you look at the S&P 500, you see that orange portion of the bar chart? That is intangibles as a percentage of the balance sheet of the Fortune 500 companies. 80%. The bulk of that is intellectual property. So all of you who invest in the stock market and you're very happy, you know, you think you're buying stock in real companies, well, you're actually buying intellectual property bets. That's what you're buying. Because almost every public company now, that's really where the value is. Specific examples, Coca-Cola, HP, Microsoft, DuPont. So you are already investing in intellectual property, and you're not even conscious of it. All right, here's what I call the pure IP deals. Again, I'm in the private equity world. This is what we do. This is why it's so crucial for us to have value. And this just gives you an idea of some of the deals that have been done. And these deals are just patents. No underlying business. Just the patents. I mean, $7 billion, $12.5 billion, $4.5 billion for patents. Okay? So this is what is going on. And this is, in our business, we need this kind of intellectual property protection. And that is becoming the new global currency. So here we are, another time for a cartoon. Okay? All future ideas are already covered by overgeneral patents. Best strategy is to get out of this business and become trademark infringement lawyers. I mean, this reality has kind of snuck up on us, and most people are not conscious of it. So how do we invest? We invest using multiple models, right? You've got angel investors, early stage investors, you've got traditional cash-based VCs, you've got the big corporate companies, and you've got public markets. In the VC world, which is akin to ours, in my firm, we invest in both venture and in private equity. So we do pre-revenue generating investments, and we do traditional private equity, revenue generating investments. But it's a huge industry. And both of these industries require intellectual property as a sine qua non. Okay? So over 480 venture firms in the States right now. In 2012, last year, over $27 billion was invested. And in the life sciences space, pretty big chunks of that was also invested. The private equity world is similar, just a little bit bigger. So $361 billion. This is just US, by the way. So this is pretty big numbers, okay? Much bigger than most countries, okay? And again, you do a whole bunch of deals in that right. There's a firm out there which is even more extreme than what we do. We are in the private equity side and the venture side, but there are now what is referred to as pure IP firms. And probably the leading one is Intellectual Ventures. They manage close to $5 billion, and all they do is buy patents. And when they get the patents, guess what they do with it? Any suggestions? Anyone knows what they do? Sorry?
They sue everybody in sight.
Absolutely. And their mothers also. They just sue. They're very effective. And from that, they make a significant amount of money. In fact, Intellectual Ventures now holds around, 35,000 patents? They probably have, somewhere close to the fifth or so largest patent portfolio in the world? One company, one firm. This is the power of intellectual property. This is the basis of what we're doing in the private equity world and the venture capital world today. So what do we do with those who don't quite join the club? What do we do? What do we do about China and India? You read in the press all the time about, they're breaching someone's patents or copyright. There's a recent case that came out last week where the Indian Supreme Court held that Gleevec, which is a cancer drug, has a new variant of it, a new version that Novartis had. And the Indian Supreme Court ruled that they were not going to give patent protection to it. All hell has broken loose. Novartis is pissed. A whole bunch of countries are upset. People are threatening, death and destruction. The US government has got involved with it. And what you are seeing is that there are certain countries in the world that are kind of pushing back a little bit. They want the benefit without having jumped through all the hoops. So there are countries that have this mint for this new global currency, and there are countries that don't have the means. And the question is, how will we deal with this going forward? From an economic perspective, we watch this very closely because we need intellectual property to make the investments that we do. Bottom line, this has become the new global currency. It is what is driving value. I can tell you without a shadow of a doubt that you guys are going to have to wrestle with these issues. The likelihood that most of the young people in this room live to be an active 100 years plus is very high. If that happens, then the only reason that will occur is because science has progressed. And the only reason why that science is relevant is that there's some kind of intellectual property around it. So this is going to be an issue that you're going to have to deal with. There are significant economic benefits from this, but there are equally significant ethical and moral issues that you have to deal with. And my view is I'm a committed capitalist, but I'm also a committed human being. And I think that you have to start sensitizing yourself to the two sides of that equation, the economics of it and the morality of it. And this is the time that you need to start debating that. I'm done. Any other questions? The eloquence of silence is always so nice. Yes, sir.
I have a question. There are noble intellectual chapters on the other end saying that intellectual property rights is stifling innovation because open source communities, they can't take the old idea and improve on the old process. What's your thoughts on their counter arguments? Well, I know your thoughts, but like, can you go into more insight on the counter arguments?
Remember the first thing I said, that the amazing thing about intellectual property is that we made it up, okay? So I even though I make a living out of this and I enjoy it, I believe that we should be open to a debate about intellectual property, both in terms of the scope of it, in terms of what is patentable, and the length of that protection, okay? So right now, trademarks are forever unless you besmirch it and you make it generic. Copyrights in the US is the life of the author plus 70 years. Patents are 20 years worldwide. So I think that there is space for a debate. Should patents be 20 years? Should copyrights be 70 years plus the life of the author? And so on and so forth. And I think the open source argument, it's an interesting one. What I would say to you, however, is this, that in the US, we take property very, very seriously. And one of the unique rights you have, if you have property, is the right to commit waste. So theoretically, if you are crazy enough, you could buy the Mona Lisa and burn it. And in the US, nothing can stop you from doing that. Now, in France, you get sued. You can't do that. You know, there are rights that you cannot take over, even if you do a commercial transaction. But America is a capitalist country, and we allow complete rights over property. So the open source community are folks who have chosen to give up their rights. That's perfectly right. The question is, should they have the right to tell other people who don't want to do that, that they have to do that? So I think there's space for a debate on that. And I'm hopeful that your generation will be engaged in that debate. Yes, sir. We're already doing that. Well, look, a classical definition of a market, right, has three elements, right? You guys are all doing business. So what are the three elements of a classical definition of a market? You've got the buyer, you've got seller, and what else? Huh? Nah. What is the middleman in the classical market? Information. There has to be a disequilibrium of information, right? So the glass is half full or half empty. The guy who's selling thinks it's half empty. The guy who's buying thinks it's half full, right? So what we have here is the classical market situation. There are those who think that nothing is out of hand. There are those who believe that we're doing fine. There are those who believe that 20%, 25% of the human genome being patented is perfectly fine. In fact, they want it all to be patented. And then there are those who believe that it's not the right thing to do. That is going to be worked out in the free market. And it will be worked out also with policy issues that you guys are going to be engaged with. I always ask the question, and I phrase the question very carefully, what would we do as a society when we eventually get a sentient being that we designed? What would we do? I didn't say human being, by the way, intentionally, but a sentient being. Because right now, there's nothing stopping us from owning it under our current law. Do we have a 13th Amendment problem again? So these are fundamental issues. And my point is that this thing kind of snuck up on us, and most of us haven't thought it through. We just have been going ahead with intellectual property.
Thank you.
Yes, sir.
What are your thoughts on first to file versus first to create?
No, first to invent, first to file. Let me quickly make sure everybody knows what we're talking about. Because we made up these wonderful rules, it's like a game, right? Tennis, right? The first serve must be in the first box. Why does that make sense? Huh? Yeah, but that's the rule of the game. If you want to play tennis, that's the way you play. Okay. So one of the rules we made up was that how do we get a patent issued? Because it's an absolute exclusive right. Don't forget, with a patent, if someone gets a patent, if someone else comes up with the same brilliant idea, independently, they still don't get their patent. This is a very powerful right. So we decided that, look, it is the first person to invent, the first person to create, the first person to invent that will get the patent. Makes sense? Fair? It's only one problem. How do you know? How do you know who's the first to invent? And for many, many years in the States, that was the rule. So you now have to bring evidence to say, this is when I invented it, and so on and so forth. So we decided to make the rules a little bit easier, and we said, the first to file. The first guy that shows up at the patent office. So now you have screeching cars rushing to the patent office to make a filing. Is that any fairer than the first to invent? So my point is that every time you have a rule, human nature adjusts to it, and there are vested interests that crystallize. So every time you change that rule, some people are disadvantaged and some people are advantaged. I can understand the logic on both arguments. If the first to file rule, which is now the new rule, is much easier to police and will reduce litigation, because you don't have to start doing evidence as to when you invented it. But it is unfair on those who don't move quickly. Now, there's a public policy argument that says the better thing for society is the first to file. Because if you have a brilliant idea, the big societal quid pro quo around intellectual property, particularly patents, is that we're going to give you monopoly rights for 20 years in exchange for full disclosure. You're going to tell us what you've come up with. And that is the deal. So there's a public policy argument that says, you better tell us quickly than later. So first to file these are all the reasons why first to file is now the new rule. I think we're done. If no more questions. Oh, last question, sorry.
Intellectual property in the cycle that it takes to create money. I mean, when you buy the rights and then when you like cash out in some way through the sue or everything, in this perspective of the client, what is the liquidity that the clients can have, or what is the expected time for them to be? I mean, if someone has to stay in intellectual property, private equity for 30 years, 15 years, I mean, does it take like more time to collect your investment?
The answer is absolutely not, and I have not made myself very clear, so I apologize for that. The point here is that almost everything you invest in, the value proposition that it has is intellectual property. If you invest in any company right now, if you actually go and look at their balance sheet, the real value that you're investing in is intellectual property. If you invest in Google, what are you investing in? Intellectual property. Apple, intellectual property. Heinz ketchup, intellectual property, the trademark. Coca-Cola, intellectual property. That's what you're investing in. So your basic investment is in intellectual property, and it has nothing to do with the timeline of when you exit it. You will exit your investment when it makes sense. We've invested in things that are very early stage in the life sciences that have a 90% chance of failure, 9-0. And we have been able to invest, acquire the asset, and sell it to someone else who knows that there's a 90% chance of failure. And it pays us good money. We're kind of happy with that. Okay? So the point and issue is that as long as you have intellectual property protection, you can trade in this. It's the new global currency. It has nothing to do with the duration. You will make your economic arguments and decisions on your investment. It has nothing to do with the duration of your IP.
Thank you.
All right. Thank you very much for your time.